Good afternoon, everyone, and welcome to the webinar, McGirt versus Oklahoma, the Muscogee Reservation Supreme Court Oral Argument Review. We are just going to wait a minute or two to allow folks to get into the room, and then we will start shortly. Thank you. All right, everyone. Thank you so much for joining us. Again, welcome this afternoon to our webinar that's co-sponsored by the National American Indian Court Judges Association and the Muscogee Creek Nation District Court. My name is Nikki Borchardt Campbell. I'm the Executive Director of the National American Indian Court Judges Association, and I'm Paiute and Ute from Cedar City, Utah. My staff and I are currently working out of Colorado, where we are still sheltering in place, even though the restrictions have been lifted a bit. But we are happy to be able to co-sponsor and co-present this webinar with Judge Greg Bigler. Our co-presenters here are Stacy Leeds, who's the Vice Chancellor of the University of Arkansas, and Riyaz Kanji, who is a partner at Kanji Katzen. That being said, I'm going to go ahead and turn over the controls to Greg Bigler, who will begin our presentation, and then we will lead that into more of a facilitated discussion with Vice Chancellor Leeds and with Riyaz.
Thank you very much. And let's see, I guess that we are ready to go. I appreciate each of you who are participating. And we will be recording this webinar, and hopefully we'll have that posted so people can come back and look at it and listen to it later. We're not trying to have a formal continuing education format here, but we wanted to discuss those things which we think would be of interest to advocates who are following the Supreme Court for federal Indian law. I'm going to, of course, talk about the cultural and legal history of the Muscogee Creek Nation briefly, 15 minutes hopefully, and then we will have Dean Stacy Leeds, now Vice Chancellor of Economic Development at the University of Arkansas, but Dean Emeritus and Professor of Law at the University of Arkansas, talk about the laws flowing around the 5 tribes and Muscogee Nation's allotment and Indian country questions. And then, of course, we have Riyaz Kanji, who is a well-known advocate, attorney working in Indian country and representing Native American tribes, who did the actual oral arguments at the U.S. Supreme Court at the beginning of May regarding the Creek Nation's interest in its reservation status. This is, as Nikki said, being hosted by the National American Indian Court Judges Association. I'm on the board there. NIJA is the premier and perhaps only national organization for tribal court judges, and also working with the tribal clerks. They've done a series of webinars that we are very helpful and thankful for over the past. I would also mention that they were a main sponsor for our national Indigenous law graduates, for those students who graduated from the law schools this May, who unfortunately, because of the COVID-19 virus, did not have actual graduations, and we were very excited and thankful for their sponsorship with that. Muscogee Creek Nation obviously has an interest in the outcome of this matter. And so without going too much further into those ancillary matters, I wanted to just mention three things before I begin the particulars. First, I wanted to pray that everyone and their loved ones and family are healthy and safe at this time. I wanted to secondly recognize the pain and frustration and aspirations of the other people of color, and that they stay safe and that their goals may be realized sooner than later to be full participants in our society. And thirdly is that these two things and what we will be talking about and what Mr. Kanji will be discussing go directly towards and highlight how it is intimately bound with our need for Indigenous peoples to be and have Indian law bound into human rights. That we have an inherent right to exist as peoples, meaning that not just that we have a right to be alive, but that we have a right to continue our existence as tribal peoples, and to be consulted regards all matters that impact us. That is not the situation at this time. I just wanted to mention that, those three things before I forget as we go forward. We turn to the Muscogee Creek Nation legal history. We have just celebrated 150 years of our written constitutions here at the Muscogee Nation, actually 153 at this time. If we move on, the tribal towns were the original government entities of the Muscogee Nation, the Confederacy. Before removal in the 1830s in Alabama and Georgia, where the Muscogee Nation and its allies and tribal towns began, they were active sovereigns. Today, there are continuation of 13 of those 44 plus tribal towns still in existence within Oklahoma, within the Creek Nation territory. 1789 to 1817 was a time of transition as we move to the next slide. With the time we were in existence and having governmental relations with the United States, by the time of the adoption of the United States Constitution, it's important to remember that the Muscogees had a fairly strong centralized national government for purposes of relations of external foreign powers, that being the United States, France, Britain, and others. Little study has been done about the internal structures of the tribe at that time, as opposed to studying how the Muscogees related to the United States or Britain. We had laws, dispute resolutions, and cultural entities, just as any government does. And we also had our internal disputes, including famously within the Muscogee Nation, the Civil War during 1812 to 1814, that greatly reduced the power of the Muscogee Confederacy. Let's move to the next slide. We actually have written records of laws being recorded during this time of 1824. The first, murder shall be punished with death upon the person who commits the act and shall be the only one punished and only upon good proofs. This is important because too often outsiders do not think that the nations had laws and jurisdictions and governments. We had very distinct forms of government, powerful forms. We're talking about the Muscogee Nation. Other tribes differed, but they too nonetheless had these structures which controlled and resolved disputes per their own guidance. If we move on to the next slide. However, as the Muscogee Nation was still a large and increasingly unified governmental structure, which a part of the unity was forced upon it in reaction to the increasing encroachments from the United States and its citizens into the sovereign territory of the Muskogees. in order to respond to it appropriately and to validate only those treaties which were authorized by the nation, they formed more and more centralized government. Despite these efforts and a strong resistance, through the beginning in the mid-1830s, removal to the west began to occur with the Muscogee Nation, or the Creek Nation as we call it sometimes, and with the other 4 tribes of what they call the 5 tribes, which would be the Cherokees, Choctaws, Chickasaws, Seminoles, and I think I named all 5 of them, to what was called Indian Territory, and eventually after 1906 became called Oklahoma, at least partly. As the Muscogees moved and the affiliated tribes, I'm actually a Yuchi Indian who have been within the Muscogee Nation since the 1780s, which has a slightly different language, very similar culture and religion, but is not identical to them. But we are within the Muscogee Nation. That is true also for the Alabamas, who had their own tribal towns, Cashadas, and several others. But when that transition from Georgia to Alabama, which was an incredibly harsh and deadly occurrence to the tribes in the 1830s, at least with the Muscogees, we did not reconstitute precisely the way that we were in the East with the tribal towns and the primacy of these tribal town organizations, although the religious aspects continued. It's really very difficult to comprehend how hard that journey must have been and the despair and what occurred upon that. Nonetheless, the nation, Muscogee Nation, rebuilt. If we move on. From 1835 to 1860-61, the nation in this, what is now today 11 counties, are part of 11 counties centering around Tulsa, Oklahoma, and south of there, rebuilt and were beginning to show significant economic social progress yet again when the Civil War occurred within the American system. That unfortunately divided the Muscogee Nation as it divided the American nation, with factions on both sides. There were strong factions which sided with the North, fought with them, and died with them. However, once the Civil War ended, then the United States only remembered those factions which fought on the Confederate side and exacted its vengeance. In partial response, the Muscogee Nation adopted a written form of governance in 1867. Prior to that, it was not a written formal government. It was still tribal township oriented with the traditional chiefs, or amicus as they call them, leading that and meeting in assemblage. If we'll move on to the next slide, please. In the 1867 constitution, a written constitution adopted in Muscogee language and in English, recognized tribal courts. It gave specific recognition to them. So that 150 years ago, we see the Muscogee courts being created. And I might add, that is some 30 to 40 years before white man courts occurred in Oklahoma. The Oklahoma courts came into existence in 1906. Muscogee Nation, Cherokee Nation, and the other tribes of the 5 tribes already had courts that were up and operating fully within prior to that. Next slide, please. Now, I know that some of the well-known writers of the history books looking at the 5 tribes, or the 5 civilized tribes, referred to them that because they deemed them to have adopted a Western style government. I want to simply point this out because in part, with the Muscogees at least, they had to divide it into a house of kings and a house of warriors with separate duties, a judiciary, and resolutions. However, if as a person who participates in and is of the ceremonial life within the Muscogee Nation and Mayuchi people, this is not that distinct from what we had prior to 1867. If you go to the ceremonial grounds, we have, at least at my grounds, my friends that I know of, they have arbors where the chiefs sit. They have arbors where the warriors sit. Each has its distinct functions. Chiefs have certain functions that they're deemed to do, and they are not, and at least in a pure sense, they would relieve other matters to the warriors. Those had divisions of duties, they had requirements, dispute resolutions, all bound into those traditional forms. So this House of Kings and House of Warriors was not really that different, although it was enacted differently than what we had prior to it. And so that sometimes one interprets what one sees from what one's background is. If you are raised in a westernized system of government, you see other systems in that context. If you were raised in a traditional sense of government, you might see it in a different context. But nonetheless, what this does illustrate is the Muscogees continued to fight to retain their own traditional forms and to continue their lifestyle where they governed themselves. Next slide, please. This then was the period of interregnum period, I would call it, from 1867 to 1890. Unfortunately, the thirst for land did not stop east of the Mississippi. As the nation, the Muscogee Nation, was rebuilding itself yet again. They had rebuilt themselves after the War of 1812. They'd rebuilt themselves after they had landed in Indian Territory in what is now eastern Oklahoma, and now they rebuilt themselves again after the Civil War. But the thirst to divide up the Indian country was relentless. And one mechanism was the allotment process. Now, sometimes that was couched in terms from Washington, D.C. as a means to civilize the tribes. Now, that, of course, seems somewhat disingenuous when you have the most lawful abiding with the tribal court systems up and running for 30 years prior to what was occurring. The frontier actually was an invasion from the east by the barbarians into the tribal peoples. But allotment did manage to open up massive amounts of land to those settlers who were now moving to Oklahoma area, teaching Indians to farm. But of course, the 5 tribes had been enormously successful farmers prior to allotment, prior to 1867, prior to 1830s. Thousands and thousands of acres that they had farmed. So, if we move on to the next slide. One example I give about this is that in the 1896 was the last man executed under the Muscogee Nation laws. Trial and execution, this comes from the Chronicles of Oklahoma. Timmy Jack, who actually was a Yuchi, was at a New Year's Eve dance down by Baggs, I believe, which is just a little bit north and east of Okmulgee by about 15 miles, when he did, I believe, stab his best friend, one James Brown, on the night of January 1st, 1896. Next slide, please. He was tried and convicted. However, that was reversed or overturned upon the verdict, and he was tried a second time, and he was again found guilty. Next slide. This is a list of the prosecution witnesses: James Brown, George Long, Daniel Bigbon, Cartlane, Thomas Brown, Stan Wadey Bighead, John Stilla, Graysons, McIntosh, Haynes, Smith, Bruners, Hayes, Littleheads, and Tigers, and all. I know many of those people's families today. And so next slide, please. The verdict was rendered. We, the jury, selected to decide the above case after careful investigation and evidence, find the defendant guilty of murder as charged. So next slide. I won't go into the details, but the legend is that Timmy Jack was convicted, then released to go back to Sapulpa area to clean up his matters, and then to return to Okmulgee on a day certain for his execution, which he did. And next slide, please. All that is to show that the Muscogee Nation had a sound, thorough system of laws and dispute resolution prior to 1906 that was fully operational. That became a mechanism, that court system was a mechanism by which the United States suppressed the Muskogees and leveraged it into allotment because the Creek Nation and the other tribes, 5 tribes, dearly believed in the court systems. And by destroying or threatening to destroy the court systems, they could force allotment. Next system. And I will let Stacy go into this if she so wishes. The Curtis Act of 1898. Next slide. However, as this allotment began in 1898 and 1900, the Creek Nation and its members were stubbornly clinging to our rights as a tribe and tribal rights. There was a very strong, coherent, organized resistance to allotment. Next slide, please. This is the Dawes Commission Act. I'll let Stacy talk about that if she so wishes. Next. And then the Act of 1906, which continued the tribal governments after being threatened to destroy them totally, but did not allow the courts otherwise to enforce at least certain laws within the Muscogee Nation. Next slide. And this was, of course, G. William Rice stated about the final disposition that it was to liquidate the interests of the 5 tribes, but it indicated that they did not extinguish tribal governments, but only rendered unenforceable certain of their laws and vacated certain tribal government offices. At that point, then thereafter, 1906, the chiefs of the 5 tribes were appointed by the president until 1970. Forward, please. As I said, the Muscogee Nation was actively resisting the allotment process. Within the Muscogee Nation was Cheeto Harjo, or known as Crazy State. The Yuchi and Muscogee chiefs and warriors of the traditional factions understood the threat that this posed to their way of life, that they believed in commonly held lands, and they understood what the nature of the relationship with the United States should be to the Muscogee Nation, and they were willing to and could articulate the problem and fight for their beliefs. They were active in this. I think the next slide may show that. Again, from the Chronicles of Oklahoma, which has an impassioned speech by Crazy Snake to the Special Judiciary, Senate Judiciary Committee, I think it is, that met in Oklahoma. And next slide, please. Yes, Special Senate Investigating Committee. Next. It has always been asking for justice. I never asked for anything else but justice. I never had justice. First it was this, and then it was something else that was taken away from me and my people, so we couldn't stay here anymore. It was not because a man had to stand on the outside. What was right that brought the troubles, what was to be done was all set out yonder in the light, and all men knew what the law and agreement was. It was a treaty, solemn treaty. What difference did that make? I want to say this to you today, because I don't want these ancient agreements between the Indians and the white men violated. I went as far as Washington and had them sustained and made treaties about it. We made terms of peace, for it had been war. But we made new terms of peace and made new treaties. I will say in passing that Cheeto Harjo was an eloquent spokesman for the traditional factions and the continuation of the intact tribal reservations of the Muscogee Nation, the intact lands prior of 1906. I would also note that part of his eloquence, I think, became because he was, I believe, the Heniha there at Hickory Grounds, which is the second chief or speaker, had the speaking functions many times at Hickory Grounds. Now, the ceremonial people all knew these older men who came from that, and they continue on. So as we move forward today, we see many of these same ceremonial grounds involved in efforts to continue their way of life. We see some of the traditional chiefs, George Thompson from Hickory Ground, where Cheeto Harjo is from, has been involved in efforts to continue on their ways and to implement the Declaration of Rights of Indigenous Peoples. So I want people to understand that this is not a one-off thing which occurred and which Mr. Kanji will speak about. It has been a continuous battle that we have always believed and always fought for. If we can go through the next couple slides, I think we'll let Stacy come back to that one. We'll let Stacy come back to the next one also. Dean Leeds. And then we come on to Harjo versus Kleppe, where we had the federal courts recognized the right of the Creek Nation to continue on its structures under its own guidance, 1976. Move on to the next slide. Next one, please. I'm not sure if Dean Leeds will talk about this, but on the west side of Oklahoma, State versus Little Chief in 1978 recognized that Indian country continued to exist in the western part of Oklahoma. And that is why tribal courts were resurrected beginning around 1978 to 1980. It took a little bit longer if you go forward. It took a little bit longer. Next one, please. In 1979, in response to the Harjo versus Kleppe case, the Creek Nation amended its constitution, which also recognized our tribal courts. And if we go through the last two slides, I think I can just conclude with saying that this is where we have come up to having tribal courts, which are always the focal point of attack upon our jurisdictions. There's some other things we can talk about, but I will simply turn this over to Vice Chancellor and Dean Emeritus Leeds.
Okay, thanks, Judge, and thanks, Nija, for hosting us here today. I'm going to talk about the property law aspect of these two cases for a couple of reasons. First, I think that there's a lot of discussion throughout Indian country nationally right now that this case is really about unique circumstances of the 5 tribes in eastern Oklahoma, and that even if this case were lost, that it might be very narrowly construed so that it doesn't have a negative impact on the rest of the Indian country cases. And my take is that the Creek Nation and the other of the 5 tribes actually have much stronger property law arguments than a lot of the other tribes do. And I think that if you think about property law, including your political and territorial boundaries, and if this case, holds for the tribes, I think that it sets, a really bad precedent and sounds some alarms, because you will have a case where there were really strong property rights and no specific congressional language that could be construed as disestablishing a boundary. And I think that that's just cause to sound the alarm. So I just want to start off by saying that this case is deeply important to those of us from the 5 tribes, but I think that it's also a very pivotal case for the future of Indian law as a whole. The other reason is that during the oral arguments, it was very clear that at least a few of the justices were looking for ways around the application of Solem versus Bartlett and Nebraska versus Parker. And in those cases, the court had previously ruled that the legal term of art Indian country continues and still exists today, even where allotment has taken place and non-Indians have come inside of a territory and that they now own land as a result of that allotment process. But up until this point, we've got pretty definitive cases that say the boundaries are not impacted just because you have non-Indian landowners inside of your reservation boundaries. And so those cases, you know, are pivotal. And I think that there's a lot of push from what I heard in the oral argument about how we can distinguish this Creek Nation case from those. And so what I'm going to talk about in the context of the property law scenarios is that, you know, I saw in the oral argument that the justices that seemed skeptical to the tribe's position tended to fall in one of two camps. And so I call the first camp the actual state of things camp, right? And these are the justices that are very troubled by the number of non-Indians who actually live inside Creek Nation boundaries and the number of actual cases that might get overturned as a result. And so they're focusing on the subjective test of whether this reservation feels Indian enough to retain its Indian country status, as opposed to looking at the statutory language. The second camp are the justices who I say are falling into this totality of the laws camp, right? And they seem to be persuaded that there's this litany of statutes that apply in these cases. And when you read them all together, and those statutes deal with land, they deal with the allotment process, they deal with temporary or permanent reductions in tribal authority. And when you read those all together, that even though you don't have that definitive disestablishment language that the court previously looked for, it still is enough to say Congress didn't really mean for there to be a reservation in the modern sense in the Creek Nation. And so I'm going to spend my time talking about that second camp, the totality of the laws, because I think if you dissect these and look at the specific statutes, it really begins to tell a much different story than what the state of Oklahoma and the Bureau of Indian Affairs have been telling, you know, for the last 120 years. So first, I want to spend just a little bit of time for those that aren't familiar with the 5 tribes in Oklahoma about the creation of the reservation boundaries themselves. And as you all likely know, the reservation boundaries are set up after the removal process, right? And you've got Cherokee Nation and the other tribes just watching what had happened in the United States Supreme Court with the Cherokee Nation versus Georgia and the Worcester versus Georgia cases. And all of the 5 tribes, looking at how that removal process went down, they are looking at that scenario and saying, you know, wait a second, the federal protection that we thought was there is not there at all. And so when they set up the new boundaries, they insisted that these lands not have this undefined federal trust status, but instead that they would be fee title lands so that there would be more of a guarantee in the American property law system for the protection of those lands not being taken away in the future. So they insisted on and they received fee title to their lands. And that came first with the treaty, but it was memorialized in a land patent or deed after the fact. And that conveyance from a property law standpoint that was issued by the federal government with the tribes as the grantees in this deed or this patent, I think it's really important to see here that this is not just as the tribe would have understood it at the time, but it's the fee title type language that would have been recognized in property law today, as well as back when those fee titles were issued. And that's a really important case, a really important point. You know, this fee title also comes with treaty language that says there's never going to be a future state involved, right? So that conveyance over to the tribes, unlike we've seen in other parts of Indian country, didn't come with this implication that later down the road there would be a state that might have some reversionary interest. There was nothing left over. That conveyance is from the federal government over to the tribe. And I think it's also important for us to remind ourselves that this has already been litigated in the Supreme Court, right? The Arkansas riverbed cases, in those cases, the court said, yeah, the federal government deeded these to the tribes, the 5 tribes. The tribes hold that in fee, and nothing was held back or retained that would pass on to a state later. And so it sets up the situation where the tribes in the eastern part of Oklahoma do not have the same scenario as you see with Indian country in cases like United States versus Montana. And so, you know, from an Indian's canons of construction, we don't have to get to the question of how the tribe would have understood it. They certainly thought fee simple absolute, as did the federal government at the time. And so if you want to think about, you know, the starting point for this case, it really is the most definitive kind of Indian reservation that has ever existed. The tribes owned it outright. And so, you know, I want to start with that point. So that's what we have when the federal government push for the allotment process starts coming forward. You had the 5 tribes as the actual property owners, as well as the governments that were exercising full dominion over the territory pursuant to tribal law. And so I want to spend a little bit of time talking about how allotments operated mechanically here with the 5 tribes, as opposed to what you see throughout the rest of Indian country. And so first, let's just talk about the General Allotment Act of 1887 itself, known across Indian country as the Dawes Act. That act did not apply to the 5 tribes in eastern Oklahoma. In fact, they were expressly exempted from the General Allotment Act. And they were exempted partially as a policy decision, but also as a legal decision. And so from a policy perspective, if you study what was going on around the time of the allotment, you know that the federal government wanted to start the allotment process with the reservations that were going to be the easiest to allot, right? They were viewed as the ones that were ripest for that type of work, smaller risk, and also fewer complications. And there was a clear understanding at that time that this was not going to be easy when it came to the 5 tribes. And it wasn't going to be easy in large part because of the legal complication of the tribes actually owning this land in fee. And so Congress actually doubted at the time whether they had the authority to allot the tribal lands absent tribal consent. So what they started to do is tiptoe around that with a number of smaller, lesser pieces of legislation, trying to kind of tiptoe in the water to see what might fly when it came to this pressure toward Oklahoma statehood. And so if you look at what's going on in the late 1890s, in 1897, Congress passed an act that extended criminal jurisdiction into territory for criminal cases only first, right? That was the first bite at the apple. And that was a test, but if you think about criminal jurisdiction in Indian country in 1897, this is really telling. And it's also very interesting because for the rest of Indian country at the time, the Major Crimes Act was passed 10 years earlier. And so we already have a full decade from 1885 to 1895 where federal criminal jurisdiction was being exercised in Indian country all over the place, except for the 5 tribes. And the 5 tribes, as Judge Bigler described, were still hearing all kinds of cases, including trying capital murder cases and executing people. And so if you think about Talton versus Mays, the famous Supreme Court case that came out of the Cherokee Nation that went up to the United States Supreme Court, the US Supreme Court heard that case in 1896. And so at that time, there wasn't anybody except for Bob Talton, who was the defendant in that case, that was trying to get out of tribal courts and get the feds involved. And so the Cherokee Nation kept custody of Bob Talton for several years while the Supreme Court was waiting to hear his post-conviction relief. And at no time during that did the US Attorney's Office try to come get him to take him into federal custody for federal prosecution under the Major Crimes Act, because everyone knew that it didn't apply to the 5 tribes and that there was a difference here based in large part because of treaty language and that exclusive intra-tribal jurisdiction that the tribes had after all the other tribes were already subject to Federal Major Crimes Act. And so the federal government knew that these tribes were not going to consent to allotment. And so they started passing these coercive sets of laws that were intended to threaten tribes to eventually agree to allotment. But I want to point out that most of these laws that got passed in the late 1800s, 1890s, they were not necessarily meant to be permanent. They were meant to compel agreement with allotment by the tribes. And so I want to talk about a little bit of a misconception around the abolition of tribal courts. And so, you know, we have all heard there's no reservations in Oklahoma and all their tribal courts have been abolished. Well, you know, the reservation piece is the point of this whole case before the Supreme Court, but the piece about the abolition of tribal courts. So there's 2 separate statutes that talk about trying to abolish tribal courts. The first one is this 1896 Act that I mentioned, but it was an act that had a qualification in it. And it said, we're going to terminate your tribal courts if you don't agree to allotment. And it gave a specific date where they were trying to compel that compliance. And so when the allotment agreement were later ratified, there was the suggestion, at least in this first instance, that suspension of tribal courts would be temporary. Now, the second act that mentions tribal courts are the more notorious act, and that's the Curtis Act of 1898. And it abolished tribal courts, but it also had an escape clause in it. And it said, at least with respect to the Choctaw, Creeks, and Chickasaw, that if they signed their allotment agreements by December 1st of 1898, then their courts would not be abolished. So it was this clear coercive tactic. And so the Choctaws and the Chickasaws actually agreed by that date. And so I think they always have had a free and clear tribal court abolition argument by virtue of the language of the Curtis Act itself. Now, the Creek Nation signed their allotment agreement past that original deadline. And so from the federal government's perspective, they didn't meet the deadline, therefore their tribal court was abolished. Now, it was later revived, of course, because Judge Bigler is signing in from the courthouse in Muscogee for the Cherokee Nation. But I just wanted to throw that out there because I think that in Cohen's Handbook on Federal Indian Law and a lot of these earlier cases, we see the Oklahoma tribes exempted out as if it was a unicorn situation, where all over Indian country, we saw tribes' governmental powers reduced and then enlarged, right? We've seen it in Public Law 280, and then there's a way out of Public Law 280. We saw it with Oliphant, and then there was a way around Oliphant with a congressional fix. And so I just want to throw that out there that we need to stop as attorneys and advocates just going along with this theory that all of these things were abolished and somehow had to be revived by the federal government later, because at least with respect to 3 of the tribes here, that's simply not the case. So I would just ask us to all refrain from agreeing to that proposition, and that the narrative around tribal courts in Oklahoma should be this: the United States used our courts as a weapon to compel us into the allotment agreement, but those courts, of course, were subsequently revived and reestablished in some combination of tribal activity and federal recognition of that tribal activity. All right, so back to the property law mechanics. Probably the #1 reason that the allotment was forced on the tribes by a particular act is this June 1898 Act. And the June 1898 Act gave over to the Secretary of the Interior the power to lease oil and gas and mineral estates under some of the 5 tribes' land. And in federal Indian law, we've all heard about the case Lone Wolf versus Hitchcock, but the case that's more relevant to the 5 tribes in Oklahoma is Cherokee Nation versus Hitchcock. And the Cherokee Nation challenged this 1898 statute, arguing that the Cherokee Nation owns their land in fee, and Congress could not pass a statute just giving to the Secretary the authority to issue oil and gas leases on Cherokee Nation lands. And, you know, I like to make the analogy that this Cherokee Nation versus Hitchcock case was the Johnson versus McIntosh for the 5 tribes, because what the Supreme Court said in that case is, they said, I'm not sure what kind of title it was that you have, but it's not for the courts to decide if Congress gives the authority over to the Secretary to issue these leases on your land. And so in one fell swoop, they have taken this clear fee title that the tribes had and diminished it to something else. And at that moment, the tribes knew that they couldn't successfully resist allotment, or they were just going to do what they would do with your lands anyway. And so much like the removal process, the tribes at that point were you know, compelled to participate in these allotment agreements so that at least they could do allotment in a manner that was more consistent with what they would want to see, rather than have the federal government completely run that show. So the allotment process starts to take place, but the federal government still has a problem. How do you effectuate these allotment deeds and make sure that there's clear title for future alienation of that land when the deed is in the tribe's name itself? And so unlike all the other tribes where the allotment deeds are the Secretary of Interior issuing the deed to the individual allottee to be held in trust from that single moment, with the 5 tribes, the agreements have the principal chiefs making a conveyance to their individual tribal citizens. So you have a tribal to tribal citizen intra-tribe fee conveyance. And so one of the arguments that Oklahoma raises in this case is that there's all this fee land inside of the Muscogee Creek Nation. And of course that's true, because it has always been fee land, you know, this entire time. And so the mechanics of these allotment deeds, now the individual allottee, the tribal citizen, has that deed and they're the fee title holder. And now after the fact, there is federal legislation that puts restrictions on alienation on that fee land. And so that's all done statutorily as opposed to as part of that conveyance itself. So that's why in Oklahoma, we have restricted fee lands instead of trust lands. And then now as we fast forward, there is trust lands in Oklahoma, because tribes acquire land and ask for that to be placed in trust. But I do think that it's a pretty critical distinction that the tribes are not asking for it to be put back in trust, because it was never in trust to begin with. It has always been fee land. So, you know, a couple of things to complicate that just a little bit further. Each of these allotment agreements had land in the agreement that were expressly set aside not to be allotted. So these were things like cemeteries and school buildings and churches and other pieces of land within townships. And so just like I mentioned that the reservation itself was the purest form of an Indian reservation that exists, so too are these parcels of land that still exist today throughout Muscogee Creek Nation and the other tribes that are purely still Creek Nation lands and have never been allotted. And so there's one 10th Circuit case, the Indian Country USA case, dealing with the parcel of land where the casino in South Tulsa is located on. And that was a piece of land that was never allotted. And the court said, yeah, it's not trust lands. We don't have to reach the reservation boundary question, but that tract of land is kind of super Indian country, if you will, because it's still in fee the way it was when the Creek Nation acquired that land. So I'm coming to you live today from inside the Cherokee Nation, and I'm standing on a piece of fee land that I purchased from another tribal member. And so the chain of title on this property originated in the tribe's fee patent. And by looking at the abstract and studying that chain of title, at least looking at last names, I am fairly certain that for the 100-year period after allotment, this was sold in fee land, Cherokee to Cherokee to Cherokee. And if that's true, which I'm confident that it is, and I look at that same scenario all over Oklahoma, you know, this idea that the tribes maintain jurisdiction over this tiny percentage of land, I don't think that it really captures the full picture, because, you know, there are several, you know, multiple acres of fee land that are still pure in that they're intra-tribal, and no non-Indian or the federal government or the state has ever acquired a property interest in that land. So I throw that out there as a distinction between the tribes here in Oklahoma and otherwise. So I'm going to hand it over in just a minute, but the only, you know, conclusory remarks that I'll make is that I do think that it's a case that is really critically important, obviously, for the Oklahoma tribes, but I also think that it could be a real turning point in Indian country cases. And we're looking to the court to see if they are going to stick to statutory interpretation and the requisite language that is required, or whether the court is going to be willing to take into consideration the actual state of things, if you will, in that, you know, is there a reward for ignoring the law for a very long time and creating a situation where lawlessness, quite frankly, leads to a discomfort that the Supreme Court's just not willing now to take back. So I will pass it on at this point to Riyaz.
Thank you very much. It's a pleasure to be here. I will say at the outset that I get very confounded by technology. So 75% of my brain right now is wondering whether I'm doing something wrong, but hopefully people can hear and see me, and it's a real pleasure to be here today, albeit in this somewhat strange format, but I can see that we have a lot of participants from all over the country, so that's a real positive to our current state of affairs. I want to start with some thank yous to the co-hosts for this webinar, to Judge Bigler. One thing I'll say is that, you know, in a lot of cases, as everyone knows, where a tribe or tribes are in front of the court and sovereignty issues are at stake, that often what we will see from the other side, from the states involved on the other side, are attacks on the integrity, the viability of the tribal court system in question, as a way of trying to you know, impugn tribal sovereignty. And we, I think, did not see a single word in any of the briefs from the state or the amici in support of the state that in any way suggested that the Muscogee Creek Nation court system is other than what it is and what, you know, tribal court systems generally are, which is a terrific, functioning, robust court system. And I think that's a real testament to the Muscogee Creek courts and to Judge Bigler and the tremendous investment that the nation has made in its court system. Those opposed to tribal sovereignty couldn't even think about trying to impugn just what an effective and viable court system it is. And thank you, Judge Bigler, for that, and to your colleagues. And it certainly made our life easier to have that one sort of set of standard attacks not even made in this case. And thank you as well to NIJA, which is a terrific organization, as you all know, and I think has been, you know, deeply involved not only in doing everything that it does with respect to tribal courts, but NIJA has played a very important role on this set of issues about the viability and the robustness of tribal courts, and has filed some very important amicus briefs in the court on that point. And NIJA's support for litigation efforts in the federal courts has been, you know, deeply appreciated. And the third thank you I want to make, of course, is to the Muscogee Creek Nation itself. It has been a tremendous privilege and honor to represent the nation, first in the Murphy and now in the McGirt case. Really the privilege of a professional lifetime for me and for my colleagues in our firm to have had this responsibility of appearing first in the 10th Circuit and then in the Supreme Court in defense of the nation's historic reservation. And again, our life in terms of the litigation has been made that much easier by the fact that the nation has such a robust governance. And again, in these cases where tribal sovereignty is at stake in the Supreme Court, a favorite play of the other side is to suggest that the tribes are not up to governing the territory in question, to try to take shots at tribal governance. And while the state of Oklahoma and its amici certainly attempted some of that here, again, our life was made so much easier by the fact that across a wide variety of subject areas, the nation's governance is so very robust, and we really enjoyed talking about all the different nation departments and the nation light horse police, and discussing just how robust that governance is, which is, I think, a good lead into what I want to do is just make a few points about what was on our mind going into the briefing and argument in the McGirt case that this term, how that was informed by the work we'd done last term in the Murphy case, what differences we saw with respect to the arguments and what that might suggest about where the court is, and then really to hopefully open this up for, and I don't quite know how this works in this format, but open this up for some questions and conversation, because that's what I really enjoy having. One of the, as Judge Bigler mentioned, when we were talking just before this panel started, in some ways this feels a lot like Groundhog Day. We, I think, as most everyone on this webinar will know, we are in the sort of second round of the fight over the continued existence of the nation's reservation in the court, because last term in the Murphy case, the court ordered a re-argument. So when we were getting ready for the argument this time around, as we liked to joke, we sort of had the benefit in some ways of having had a moot court in front of the Supreme Court, of already having gone through that process once. And one of the things that I noted to be a real difference in the court's questioning this time as opposed to in the Murphy case is that there was far less questioning about the current state of the nation's governance. So that whereas in the Murphy case, we felt like we had to do a fair bit of educating of the court, and as everyone knows, the court is not necessarily the best versed in issues of tribal governance and what the state of play is on the ground in Indian country. The last time in Murphy, we spent a lot of time discussing just how robust the nation's governance is in a wide variety of areas, and felt like we really needed to educate the court on that. And we had some tremendous amicus support in that regard as well. This time around, we did not take any of that for granted. We did spend a fair bit of time in the briefing, and especially had great amicus support on this in talking about on the ground governance issues. But the court's questions were far less active in that area this time than last time. And I think that's because the court, having gone through the drill once, had an understanding, a good understanding of the sophistication of the nation's government, such that the justices that I think may be our allies on the court felt less of a need to sort of have concerns addressed about that, and the justices who may be less sympathetic didn't really see that as an avenue of attack on the nation's position. So that was one, I think, interesting takeaway from the argument this time. The second, in terms of area of the court's focus or lesser focus, the second area where we felt less focused this time was on the immediate post-statehood period and what the nature was of the nation's governance at that time. In the last argument in Murphy, that was a real focus and argument. And some, especially the justices who were less sympathetic, were trying to make a real point out of saying, look, what examples can you point to of the nation's governance in this post-statehood period? And isn't the fact that the governance was less robust then than it might be today indicative that Congress, in fact, did disestablish the reservation, hence there was no territory to govern over, hence there was no governance? Can't we draw that sort of set of conclusions? We spent a fair bit of time in briefing this time around on that point, and made the point with which both Judge Bigler and Dean Leeds have made very well, that that whatever lessons one wants to draw about reductions in the nation's governmental powers as a result of the series of statutes and treaties that they both discussed very well, that one has to keep in mind that that with the 5 tribes, one was starting from a very high baseline, and that the 5 tribes had this robust set of courts and a set of governmental structures that much as Congress sought to chip away at those, where they ended up was still, in comparison to Indian country writ more large, was still with a set of governmental institutions that were the equal of or greater than many tribes across the country. So if one was going to look at the quantum of governmental power as a measure of reservation existence, and of course those don't really line up as a logical matter, but if one was going to, that the 5 tribes still compared very favorably. And what we tried to do in the briefing was to make the point that in the early part of the 20th century, Congress and more specifically really the executive branch, the BIA, were really taking very significant whacks at tribal power, and that we were in this era of administrative absolutism where BIA officials were really acting like czars across Indian country, and that one couldn't draw from that sort of administrative absolutism any lessons about the continued existence of reservations, or we really wouldn't have any reservations left in the country. That point, I think, seemed to may well have resonated through the briefing, because again, there wasn't a lot of focus on that set of issues in the argument. Instead, what we saw were the points that Dean Leeds alluded to in her categories, and I like her labeling. But with respect to sort of 2 sets of issues, this totality, what she called the totality of the laws camp, where we had certain justices kind of picking and choosing some of the statutes from the latter part of the 19th century and trying to draw conclusions of disestablishment from those, even though I think at this point the court understands that there is no single statute that contains any hallmark language of disestablishment. So there's no one particular focus that those who are hostile to the reservation's continued existence can look to. So it's more a question of trying to weave this narrative from a set of statutes. And Dean Leeds and Judge Bigler did a very nice job of elaborating on those, and I won't repeat anything that they said. But that's where we had questions about especially the 1897 Act that has been discussed, and this sort of argument that, well, that law subjected all in the Indian Territory to the jurisdiction of the territorial courts, irrespective of race. And some of the justices picked up on that phrase and sort of used it to argue that, well, all distinctions were meant to be abolished in the Indian Territory, and can't we infer from that the continuation of reservations post-statehood would have been anathema, and in fact would have continued the very distinctions that the 1897 Act sought to eliminate. So that was sort of one line of arguments that we heard from those who seemed less favorable, and the second, as Dean Leeds pointed to, was sort of this group that we're focusing on the state of affairs, the actual state of affairs on the ground. And there, it was interesting because, as I say, there was much less focus this time on civil consequences and the robustness of the nation's government. The focus for that group, and of course there's some overlap between those two, was really on the criminal consequences, and wouldn't, given the large number of non-Indians in the Indian in what was formerly the Indian Territory, wouldn't we be asking the federal government to shoulder a huge burden in terms of criminal prosecutions, and B, wouldn't we be risking the overturning of a lot of criminal convictions on collateral attack if we were to hold that, for all this time that the state's been prosecuting Indians in this area, it really should have been the federal government. So that was sort of the second camp. I'm hopeful Dean Leeds didn't specifically enumerate this, but I'm hopeful that there was a third camp at argument, which was what I would call the follow the law camp of justices who will be willing to adhere to the established framework for reservation cases, which really is nothing radical, but this notion that if Congress is going to abrogate reservations or abrogate sovereign powers, it must say so. It must clearly evidence its intent to do so, either through clear statutory language, which of course is the test that all other sovereigns enjoy, state sovereigns enjoy. But at the very least, if there's not crystal clear language, absolutely unequivocal evidence in the surrounding history. Will the court adhere to that test? We certainly have some justices who were, I think, pressing pretty forcefully in that direction, especially Justice Kagan, Justice Sotomayor, and I would say Justice Gorsuch, who was, the new voice on the court in McGirt since he was recused in Murphy. I think where the decision may come down to is really Justices Breyer and Ginsburg, more in the middle, who were sort of showing a lot of different signs. They showed signs that they are not willing to jettison the existing disestablishment framework, but they also showed concerns in Justice Ginsburg's case, especially about the overturning of criminal convictions, and they showed concerns in both their cases, and especially Justice Breyer, sort of picking up a little bit on this narrative of the laws and this question about whether perhaps even if the reservation continued to exist, was there a transfer of criminal jurisdiction to the state at statehood, and that conveniently would also help with the overturning of criminal convictions point. In other words, even if the reservation continued to exist, the fact that Oklahoma has since statehood prosecuted tribal members for over a century, that would have been sanctioned by Congress and would not allow for challenges to convictions now. And so there really are sort of three possible outcomes in the case. One, the nation loses outright, the reservation is held disestablished. Two, the nation wins on the reservation question. It's the boundaries are affirmed, and the criminal convictions are vacated. The third, which would be, and this could take a number of different forms, would be either a holding that the reservation continues to exist, which of course would be great for the nation, but criminal jurisdiction was transferred to the state, or the court stays agnostic on the reservation issue, says we don't need to get there because jurisdiction was transferred, and that's all we need to do to hold, to decide in the cases before us, which would leave the five tribes, alive to fight another day on the reservation issue, but would of course be somewhat, at a minimum, anticlimactic given all the effort that's gone into fighting this battle over the last few years, and would clearly have repercussions in the criminal arena. So those are some different possibilities coming out of argument. I'm very interested in always in thoughts as to what people, what others thought about the justices and where we might be going. I think with that, I would like to stop and see if we have questions for any of us and can have a bit of a conversation.
Riyaz, this is Nikki. For the attendees and the participants, if you look down at your toolbar, there's going to be a button with the letters Q and A on there. Feel free to press on that button and it should give you the option to go ahead and ask questions directly of the panelists. And Riyaz, we currently have 2 open questions for you.
Right, okay, thank you, Nikki. The first question is, when do we expect a decision? I think the court is going to try very hard to honor its traditional schedule of wrapping this term up by the end of June, and given what it did with the scheduling of arguments, where it had remote arguments in about half of the cases it had pending for March and April, it should be able to abide by that. So we expect to have a decision by the end of June, and likely my guess is our case will come down to pretty late in the month, given that it was one of the later arguments. We did have a pretty strong sense from argument that what likely happened in Murphy is that opinions were circulated by the court in an effort to get to 5 justices last term. There was probably some pretty robust back and forth. And when the justices were asking questions this time, you could tell that some of them, really had a solid handle on some of the legal nuances, which may well have been forged through the drafting of opinions. So they probably have a pretty good head start on opinion drafting. A lot of this may come down to what role Justice Gorsuch is going to play if he's writing a lead opinion or writing a significant concurrence. That could get us right to the end of the term. If he's going to sign on and sort of provide a 5th vote for an existing opinion, then we could be a little bit earlier in the month than that. So that was one question, and then another one I see is, what role do we think the Sherrill case will play in Justice Ginsburg and Breyer's view in McGirt? That's a very interesting question. We had a lot of discussions about Sherrill sort of in doing the briefing and in preparing for argument. It's one of those tough things as an advocate in some ways, because it's obviously that's a horrendous opinion. Personally, it's one of my least favorite Indian law opinions, and of course they're a good number to choose from. And so it's not an opinion that we really wanted to stress, to say to the court, well, even if you hold even if you hold that the reservation exists, you can come back later and say that the tribe has lost a good chunk of its powers by virtue of the passage of time. But there were suggestions, made to that effect in an effort to give, especially Justice Ginsburg, the author of Sherrill, some comfort. And I thought it was very interesting that, one of the questions that Justice Kagan asked me was about Sherrill and what role I thought it would play. And I think she was clearly, just as she did Justice Kagan is very savvy. She's a real coalition builder on the court. I felt like in the Murphy argument, she asked me a question about post-statehood history, because she really wanted the rest of the court to hear the answer. I felt like this time she was asking me about Sherrill because she wanted at least one or more justices to hear the answer. And I suspect that was, again, directed at as the questioner has alluded to it, Justices Ginsburg and Breyer, in the hopes of bringing them along on a robust reservation establishment question.
Riyaz, one of the questions I think I heard consistently was from people afterwards was, I think Chief Justice and some others talked about the race-based distinctions that, of course, for Indian law advocates gets us jumping up and down trying to raise our hand to answer. And so I was just curious. I don't think I'd heard anybody respond that it's not race, it's political. And I was just curious about your approach to that.
Yeah, that's an excellent question. And I will tell you, when it was a great frustration to me in argument, and it sort of I think there were some good things about the format this time where we had each justice, going one by one and asking questions. There were also some real disadvantages. And one of the frustrations for me was I wasn't asked specifically the question about the 1897 Act. Those questions all went to Ian Gershengorn, the counsel for McGirt, and I think Ian did a very good job answering the questions, but did not get to the point that you just made, Judge Bigler, about we're not talking about race here. We're talking about political sovereignty. And when I sort of do my ritual, when I did sort of my ritual beating up on myself after argument, which I do quite a bit of, that was the point where I kept thinking to myself, is there a way that I could have worked in that answer? Because I really wanted to give it. I felt a little stymied by the format and just wasn't able to get to that point. And I've since gone back and listened to the argument a number of times and have thought of different junctures where the point might have been made. And I took a long run the day after argument, and I sort of this answer came into my head of things I would have loved to have said about that, along the lines of what you just pointed to. And I got home and I told my wife what I'd been thinking of, and I was all fired up, and she said, you couldn't have said half of that. Like you just, it sounds good now, but you couldn't have said it. But I do wish that was a point that I had managed to make in a number, in a couple of different ways. One is, that 1897 Act and the irrespective of race language, that also, that clearly wasn't just applicable with respect to tribal members. That had a lot to do with, with the black citizens of the territory, and argue that post-statehood, all racial distinctions were eliminated in Oklahoma, and that's the prism through which the law should be viewed, is, that's absurd. And of course, Oklahoma, as everyone on this call knows, was a Jim Crow state, and race distinctions were rife through the law. So to use some notion of, color blindness, lack of color distinctions to suggest that tribal sovereignty, which is an entirely different matter and a political issue, was abrogated. You have to go through several leaps of illogic. But as I say, it's not a point I made. It's one I wish I had made, and it is a point of some concern, because there clearly are justices on this court who really view a lot of things through this Bible of color blindness, and for whom that 1897 Act language is I think in some ways a very convenient way to argue against reservation distinctions.
I think there's two other questions I think that might tie together perhaps from our perspectives. One is, what impact would the decisions, how could a negative impact the tribes outside of Oklahoma? And then also that Oklahoma's argument about the dependent Indian country, I think, is 1151B. I know that was like, trying to draw distinctions. And I thought that went perhaps even to the question last year, or was it earlier this year, about when is a reservation not Indian country, or I can't remember what the reverse was after your oral arguments that all had us scratching our heads. And yes, we all learned that they can go really bad when they make a decision.
Right. Yeah, no, exactly. All excellent questions. On the first point, repercussions if we, heaven forfend, if we were to lose, of course, it all depends on how the court frames that. If the court, and as Dean Leeds suggested, the difficulty here is for us to lose, the court in truth really in some ways has to abandon or water down or walk away somehow from the Parker-Solomon framework. And the manner in which it does that could have significant repercussions for other reservation boundary cases. If it either, infuses more life into the third step, the sort of demographics and post-history step of the Parker-Solomon framework, that would be of course of real concern in other cases. And one of the beauties of the Parker decision was that it seemed to really relegate that third step to where it belongs, which is nowhere. But if the court is to revive it, that's going to be something, we'll be dealing with in cases in the rest of the country. If it were to do something, as you say, Judge Bigler, like to go off on this dependent Indian community argument, that again could have some significant repercussions, because that's just not an argument that really is, I think, people on this call know. When you look at the doctrine and what a dependent Indian community is meant to be, that would be a very significant change in the law to all of a sudden elevate the importance of dependent Indian communities and subvert the significance of what clearly were reservations. And as Dean Lee's well said, with the fee title, these were meant to be stronger reservations, the strongest form of reservation. And it would be turning the history and the law on its head to say, well, actually, these were some form of lesser dependent Indian community that the moment title was changed somehow exploded. That, again, for me was a bit of a frustration in the argument, because I didn't get asked a question about dependent Indian community, and I couldn't figure out a way to get there in the time allowed. But we took some pretty good comfort from the fact that even though some justices were clearly, especially Justice Thomas, were clearly interested in that point as perhaps a way to get around the Parker-Solem framework, the United States, which was no friend of the nation in this case, as everyone knows, at least on that point, Ed Needler was not willing to go there. And when asked directly about the dependent Indian community argument, he tried to sort of soften the blow to the state in terms of how he framed his answer. But it was very clear that the United States, and this is clear from the briefing too, did not think that was a viable legal argument. And as a result, I think that by itself would preclude 5 justices from wanting to go in that direction. I see that there's a question on the chat too about, a couple of questions. One is how Justice Gorsuch is present this time around, the effect it had on our strategy. It was significant, especially in the briefing. We were, I think we were not, so nobody was subtle really in terms of playing to Justice Gorsuch. The briefing really, from all sides, tried to pick up on sort of jurisprudential themes that he likes. And that was easy for us, because really his, not just his Indian law opinions, but his jurisprudence more generally really shapes itself well in terms of the arguments that we wanted to make in this case. He is such a strong proponent of the separation of powers. That's probably the most important principle to him as a justice, which really allowed us to say here, look, this is for Congress. If Congress wants to disestablish a reservation, that's within its purview. It's not for the courts or the executive branch to affect a non-statutory disestablishment. There was a lot of nice language in this cases to draw upon. And so that's a theme that we really tried to sound, and that we try to sound in argument as well. And if, there was a lot of speculation, of course, sort of easy math, that the fact they ordered re-argument in Murphy suggested they may have been split 4-4, so Justice Gorsuch is going to be the deciding vote. If that were in fact the case, I think we would feel pretty good coming out of argument, given the nature of his questions, which really did focus on those themes. But as I say, there is some question about, where a number of the justices may well be, including Justices Ginsburg and Breyer, on these subsidiary issues of the transfer of criminal jurisdiction. The other question I see is about whether Congress, if we are successful, do we think Congress will immediately pass legislation to disestablish the reservation boundaries? I certainly hope not. Obviously, that would be a massive step for Congress to take. And I think that there would be a very significant battle over that. And one of the things that was really interesting in this case, and I think that we took a lot of stock in, and that I tried to emphasize at argument, was that, we have this, I know there are a lot of people on this webinar from Oklahoma. So it feels funny for me to talk about Oklahoma as somebody who's not from there. But one of the remarkable things about Oklahoma that you understand when you're in a different part of the country is just the amount of interaction and the relationship between the nation governments and the state government, and how much cross-pollination there is in terms of governmental officials. And we had this amicus brief filed by Oklahoma state officials, former governors, and county officials, and Congressman Cole, who of course is one of the highest ranking Republicans in the House, signing that brief. And that's a point I try to emphasize at argument, because I think it will actually matter to some members of the court to see that you had people on the state side of the ledger, voicing really in a very robust fashion support for and respect for tribal governance and for the continued existence of the reservation boundaries. So I think that especially with people like Congressman Cole, it would be extremely hard for Congress to pass sort of a straight up disestablishment legislation, which is not to say that there aren't some people who might try. I think what might be more likely would be that I would imagine that if we do prevail, there will be some form of discussions about the allocation of responsibility, and sort of take a lot of heart in the fact that there are very good working relationships in Oklahoma with the 5 tribes, and that the Creek Nation has, and that there would be, as I've said to the court in both arguments, I think very responsible efforts to ensure that jurisdiction is allocated, continues to be allocated in a way that serves the interest of all citizens in that part of the state.
Well, we are almost out of time. We are where we said we have 90 minutes, but we can go just a bit past it. And one of the things I'd like to ask Mr. Kanji, I know that you we're fortunate to have your advocacy there at the Supreme Court, and you, I believe, have been there more than once before and seen things occur and have discussions. And this goes to some extent with the question that you just answered, but what do you see as perhaps giving us a view from on top of the hill, looking out over the horizon, where you see us needing to go, and what the nature of the advocacy needs to occur, or discussions internally, so that we can prepare ourselves for whatever that next stage happens to be? For me personally, you probably know I'm kind of a believer in the United Nations Declaration, and which goes towards us a free, prior, informed consent type of discussions. But I'll open the floor to you on that.
Well, I think in terms of the court generally, and in terms of litigation and advocacy about tribal sovereignty moving forward, obviously it's a great question. It's a huge question. I'll just say a few things that are really important to me. And I always, I'm an optimist. I'm a natural born optimist, especially at a time like this. I want to end on a very optimistic note. And I think I can say a few things, in full good faith that are in the optimistic vein. One is with respect to the court itself. I think in all the years that I've been practicing in this field, which about, I'm aging myself, but a quarter century now, this is the most favorable set of circumstances we have with the Supreme Court to advance the ball of tribal sovereignty. I feel like there is, and a lot will depend on the next appointment or two, but we are in a much better position now than we have been to, in the ideal world, be proactive and affirmative in advancing the cause of tribal sovereignty, through the courts, through the American courts. And I say that, with the understanding that for many years now, we, through the Tribal Supreme Court Project and through the actions of tribes, have had to, in a very sort of intelligent and responsible way, and I think tribes have been remarkably responsible and and strategic in this regard, have had to sort of take a defensive approach to the court. You know, the game in a lot of ways has been to win in the lower courts and then try to keep cases out of the court. And the Tribal Supreme Court Project has worked very hard on that. And that has been a companion to efforts like the very important efforts like the one you're talking about, Judge Bigler, with respect to looking at other sources of law and other bodies as well, like international law and the United Nations. But we now have, with the appointments of Justice Kagan and Justice Sotomayor, a couple of justices who hopefully will be on the court for a long time, who have a real strong interest in understanding in principles of tribal sovereignty, and who are willing, I think, to be real advocates for the tribes. And then Justice Gorsuch, who I think thus far has shown himself to be, really, really strong on our issues, to really care and to really want to dig in deep. So for the first time, I feel like we have a real core on the court that may demonstrate a real understanding of our issues and a real willingness not just to not do further damage to principles of tribal sovereignty, but to try to repair some of the damage that's been done over the last couple of decades. And as I say, a lot will depend on the next appointment or two, but it feels good to be able to think about that possibility. And the second is what everyone who's participating in this webinar and people in Indian country are doing more generally with respect to the critical work of reinforcing the strength of and further enhancing the strength of tribal governmental institutions, be it the courts or the executive or legislative branches. There's so much important work that's being done on the ground. And to come back to where I started my talk, for those of us who are litigating and trying to defend tribal sovereignty in the courts, the most important tool we have is to be able to point to all the terrific efforts that are taking place within Indian country and how those are benefiting both tribal members and non-members alike. And so what's being done, and specifically here with respect to the tribal court systems, is so critical and is giving those of us who are litigating the cases in the federal courts such a tremendous base to build off of in terms of our arguments.
All right, and thank you. With that, I am going to go ahead, and I think that Vice Chancellor Leeds had to depart us already. We appreciate your time, Mr. Kanji. We were very fortunate to have you there and your thoughts. We wish the best for your efforts. And this webinar will be uploaded to the NIJA site and on the NIJA YouTube shortly, today or tomorrow, sometime this week. On behalf of the staff, the board of directors, we thank you for joining. For the Muscogee Creek Nation District Court, we appreciate your efforts and wish for the best. We hope that everybody stays safe. Prayers for everybody involved. Stay healthy, stay safe, and advocate, and don't get ridden from the efforts we make, wherever that might happen to be. So with that, we will conclude the webinar, and thank you very much.
Thank you, everybody.